Start. Para. The petitioners seek quashing of CR number 132/2013 dated 8th August 2013 registered at Police Station Sangli for offences punishable under sections 498A, 313, 494, 323, 504, 506 read with section 34 of the Indian Penal Code and subsequent final report dated 11th November 2014 filed by the investigating officer in the Court of the Judicial Magistrate First Class at Vita. The petitioner number 1 herein is the husband of the respondent number 2. Petitioners number 2 and 3 are the mother and brother of petitioner number 1 respectively, whereas petitioner number 4 is the wife of petitioner number 3. Para. The FIR reveals that the petitioner number 1 and the complainant were married on 1st December 2002 according to Hindu rites and rituals. The complainant states that she resided with her husband, brother of her husband, his wife and mother-in-law. After the birth of their minor son in 2004, the petitioners started ill-treating her. Complainant has narrated the instances of cruelty in detail in the FIR. Some of the instances are as under. First, she was accused of suffering from TB, since her brother had TB, and on this ground she was repeatedly beaten up. Second, the petitioner number 1 husband lost his job. Hence, the petitioners demanded that she bring an amount of rupees 25 lakhs from her parents to help her husband start a business. When she showed her inability to do so, she was beaten up and was not given meals. She was starved and was refused food until she met their financial demands. Third, the petitioners refused medical aid to the complainant at times when she was unwell. Fourth, she was forced to undergo abortions 3 times after the birth of their minor son on the basis that they did not want her to bear any child from their family. She has specifically made these allegations against all the petitioners jointly and individually. The role of each petitioner is specified in the complaint. Fifth, the petitioner number 2 gave her burns with a hot iron rod when the complainant tried to resist undergoing abortion. Sixth, the petitioner husband always gave threats of dire consequences if she divulged her reluctance to undergo abortion to the doctors. Seventh, they quarreled with her on trivial issues and arguments always ended in the complainant being beaten and abused. Eighth, they drove her out of the house and refused to take her back in the matrimonial home. Ninth, the petitioner husband has married another woman without taking divorce from the complainant, and he is residing with her and a minor daughter born of the lady's earlier marriage. Para. Heard the counsel for both the parties. Mr. Shinde, learned counsel, appeared for the petitioner. Learned counsel appeared for respondent number 2 and learned APP appeared for the state. Mr. Shinde submitted that the FIR was filed only after the domestic violence petition was decreed in favor of the complainant, and she intended to further harass the petitioners. She raises the issue of limitation by contending that the last incident of ill treatment, even as per the complainant, was on 14th November 2009, and therefore there is no allegation of cruelty. The FIR thus filed 3 years after the cause of action is time barred in the contention of Mr. Shinde. She further says that the FIR is merely a counterblast to the divorce petition filed by the petitioner number 1 against the complainant. She further says that the complainant is only intended to extort money from the petitioners. Stop.